We're going to talk about the Missouri Human Rights Act today. And as Pat indicated, it's very important to us that you understand what we're presenting. So if you have any questions, just raise your hand. You don't have to wait till the end of the seminar. Just raise your hand and ask the question. It's very important that you pay attention because I may ask you questions during the presentation, so be aware of that. Well, today, again, we are going to talk mainly about the Human Rights Act. And the reason we're here is because effective August the 28th, we will see the largest or the biggest changes, in my opinion, that we've ever seen in employment law in the state of Missouri, certainly in the last 20 years. But before we talk about the changes, I want to spend a little bit of time and talk about why we had changes to the Missouri Human Rights Act. And the reason I asked the question, if there were people here who may have not addressed a charge of discrimination, you may not even know what the Missouri Human Rights Act is. So let's spend a little bit of time and talk about what is the Missouri Human Rights Act. What is it? I think it's best to define what it is by comparing and contrasting it with its federal counterpart. Okay? And let's look at this from the perspective of a plaintiff's attorney. Okay, let's pretend you're an attorney and you are representing an employee that believes that he or she has been discriminated against for whatever reason. On the federal level, if you believe you've been discriminated against because you're disabled, you would seek relief under the Americans with Disabilities Act. Everyone's heard of that, ADA. If you're over the age of 40, let's assume, 40 used to sound really old to me now. 40 sounds pretty good. But believe it or not, if you're over 40, you're protected. And under the federal statute, it's the Age Discrimination and Employment Act. Let's assume that you believe you've been discriminated against because of your race or your sex. You have the Civil Rights Act of 1964. So on the federal level, there are a number of specific statutes which protect people in certain categories. Under state law, we have one statute, a very comprehensive statute called the Missouri Human Rights Act. It protects the disabled. It protects people over the age of 40. It protects you on the basis of sex, race, you name it. And there are certain advantages. If you're a plaintiff's attorney, there are certain advantages under the state statute. So when I begin to talk about how it is that we got to this point where we needed changes, I like to go back in time. Let's go back to 1996 when I began practicing law. At that point in time, if you were a plaintiff's attorney and you had a client that you believe was discriminated against, again, you had two choices. You had the state statute, this broad Missouri Human Rights Act, and you had state statutes. There were advantages and disadvantages of both. Okay? One major disadvantage of the federal statute is that you had damage caps. In other words, if you brought a lawsuit under the federal statute, you would be limited in your recovery. In other words, if you got a big jury verdict, the court would likely reduce the verdict. So you didn't like that. You're a plaintiff's attorney. You didn't like the federal statute. Whereas under the state statute, there were no limits to damages. The jury could just award, or there were unlimited damages. But there was a big problem because the Missouri Human Rights Act in the mid-90s only permitted a judge-tried case. So if you brought a case in state court, you wouldn't get a jury. Now think about that. If you're a plaintiff, if you're an employee, you believe you've been discriminated against, do you want to go before a judge or do you want a jury? What do you want? You want to go before a jury. Yeah, you don't want a judge-tried case. So what you saw happening in the mid-90s, if you were a plaintiff's attorney, you had a client that you believe was discriminated against, you would file in federal court. You would file in federal court and you would bring two claims. You'd bring your federal claim, pick a statute, let's say Title VII. Let's assume it was a sexual harassment claim. And you would bring your state court claim, all in federal court. And the reason you did that is because in the federal court system, they believed you were entitled to a jury trial under the Human Rights Act. They thought that it was unconstitutional. They didn't like that. They basically read out of the statute that you only got a judge-tried case. So plaintiff's lawyers, you had a person who was discriminated against, you filed in federal court, you tried your case, and you submitted the case under the Missouri Human Rights Act. Why? You got the best of both worlds. You got your jury trial, and if you hit a home run, a big verdict, you didn't have to deal with the caps. That was the world as it existed in the mid-90s. Well, if you're the plaintiff's bar, now the plaintiff's lawyers, they have their own group, their advocacy groups, and they're always trying to change the law to benefit plaintiffs. Do you blame them? That's what they do. They didn't like this situation. Why was this not a good situation to go into federal court? There are disadvantages to federal court. I already mentioned really two big disadvantages, major disadvantages. Number one, you have to get a unanimous verdict. Think about that. You go to trial, I mean, everyone has to agree. Think of it. How many times have you been in a meeting with people? How difficult is it to get everyone to agree? Think about that. You go try a case, you get done. Let's assume you have seven or eight. You have to get a unanimous verdict. State court, you only need 9 out of 12. Think about that. Okay. So the plaintiff's bar, they didn't like this situation. And there's another reason, and it just comes down to resources. Every federal judge has 2 law clerks. Now, I know we have some lawyers here, okay? They have law clerks. They have 2 people normally out of law school that research. And if there was a possibility in federal court that you might avoid a jury trial by something called a summary judgment motion. Now, in state court, there are no law clerks, so it would be very unlikely that a case would be thrown out of court by a judge. So the plaintiff's bar began working very hard to end this situation where all these cases were going to federal court. And in the mid-2000s, a case was taken to the Missouri Supreme Court that held unconstitutional the provision of the Missouri Human Rights Act that compelled a trial before the court. In other words, you were entitled to a jury trial in state court under the Missouri Human Rights Act, and that changed everything. I mean, it totally changed the complexion of employment law in the state of Missouri. It was huge. In just a year, virtually, or most litigation in federal court in Missouri ended as far as anti-discrimination litigation, and it all got funneled to state court. And the state court dockets were getting loaded beginning in the mid-2000s with anti-discrimination lawsuits. Why again? Unlimited damages, jury trials. This is what the plaintiff's bar wanted. And then other cases began going up to the courts, having very favorable causation standards. Multiple very positive rulings began occurring in the state system, the State Court of Appeals and Supreme Court. And verdicts, I mean, there were very large verdicts. Does anyone here have any employees in Jackson County, Kansas City area? Okay, yeah, there we go. So you've probably read some of the headlines. There were just some verdicts coming out of Kansas City that were incredible. Okay. It was a very, very favorable, beginning in the mid-2000s until this year, it was a very favorable environment for plaintiffs' lawsuits in state court. But as you might guess, with all the money that was being made, I mean, the plaintiffs' bar loved this. I mean, they were getting houses on the Mediterranean, they had 3 or 4 country club memberships, life was good. But there were certain groups that did not like this. The Chamber of Commerce didn't like it. Certain employer groups didn't like it. And in fact, I believe it was the National Chamber of Commerce described Missouri as a judicial hellhole. Okay, that's how, yeah, seriously, your state, Missouri. So the legislature got involved, and that is why we had these changes, because advocacy groups, this is a reaction against all of these favorable decisions for employees. That's just how we got here. So Senate Bill 43, it went to the Senate in March, May 8th, passed the House. Our new governor signed it on June the 30th, and it will go into effect unless, I agree with Pat, it's going to go into effect in late August. What are the changes? What changed here? Let's begin with the causation change. And I'm going to talk about it, then I'm going to tell you later why, in real life, why it's so important. The new statute replaces the contributing factor standard with a motivating factor standard. Let me go back. Prior to, and let's get to the specific language. Okay. Prior to this amendment, a variety of cases had come down holding that the causation standard under the Missouri Human Rights Act was the contributing factor standard. Now we have the motivating factor standard, which is the standard in some federal courts. So now, in order to prove a case, I mean, you're a plaintiff's attorney and you have to prove your case. You have to prove that the employee's protected classification, whether it be race, sex, must actually play a role in the adverse decision as opposed to a contributing factor. And you also will have to show that it had a determinative influence. Now think about this for a moment. This would be much easier than showing that it was a contributing factor, because a contributing factor can be one of 100 factors, conceivably. But now under this change, a motivating factor, you have to show that it actually played a role and had a determinative influence. What specifically changed? The legislature changed two definitions. Because of, you have to show that the protected criterion, whether it be race or sex, was a motivating factor of the conduct, whether it be religion, national origin, etc. And the legislature went further. Not only did the legislature make changes, but they also specifically invalidated, struck down decisions that the plaintiff's bar had pushed through the court system. They specifically invalidated the City of Maryland Heights decision, where the court indicated, basically adopted the contributing factor decision. So why is this important? Well, those of you who have been through a jury trial, what happens? You present the case to the jury, and then the judge reads off instructions. We call them verdict directors. It says, you must find for the plaintiff if you find X, Y, Z. Let's say number 1, your insert protected category, black, female. Number 2, your discharge. Number 3, sex, race was a contributing factor in the decision. Okay? Then it defines contributing factor. Contributing factor can be one of many factors. Okay? Wouldn't you much rather, as an employer, have an instruction that says you have to show it's a motivating factor? You have to played a role, that it actually played a role in the decision. And wouldn't you also like to have a instruction that shows that you can only win with but-for causation? That is the law as it stands now. Okay. This is why it's such a significant change, because when you go to a jury, it is much harder for a plaintiff to win. Okay? Much harder. It will change everything on how a plaintiff's attorney would view whether or not they even take a case. Another case, and I don't want to spend a lot of time talking about jury instructions, but there was also a case which held that courts could use this instruction, which permitted juries to find in favor of a plaintiff even if the discriminatory factor was one of many factors. Okay? It could be one of 4 or 5 factors. If the discriminatory reason was one of many, then you can find in favor of the plaintiff. And the legislature explicitly abrogated or struck down that decision as well, abrogated it. Okay. And the legislature went even further. Not only did they invalidate cases, but the legislature struck down and invalidated every jury instruction in place. So beginning August the 28th, we virtually have no approved jury instructions under the Missouri Human Rights Act. They're going to have to start over. So the point I'm trying to make is this was a wholesale change of 20 years of case law. Okay. So the first change was the causation standard. Very, very, very important. This is the part that you're going to like. Now, I have another question for you. I asked about whether you've had to sit through a jury trial. And if you feel uncomfortable answering this question, you can just remain quiet. But I know there are many human resource people here, and I suspect that someone here has been named in a charge of discrimination or named as a defendant in a lawsuit. So I'm going to ask the question, is anyone here willing to admit, and I'm not saying you're guilty, I'm just asking, is anyone here? Okay, we have someone. So see, I see hands. There are people here who have been named as a defendant or respondent in a charge of discrimination or in a lawsuit. Because are there any new HR people here who've been in the industry for, let's say, less than 2 years? Anyone? So when you were hired, did they tell you that you could be sued? They did tell you that, all right, because you can. Isn't that terrible? Yeah. Under the Missouri Human Rights Act, as it exists today, and for another few weeks, they define employer. Today, the Missouri Human Rights Act defines an employer as the employer and anyone acting in the direct interest of the employer. And that means you. I mean, it could be if you're directly involved in the decision, you could be fired. And the Missouri Human Rights Act is not the only anti-discrimination statute that provides for individual liability. The Fair Labor Standards Act, did you know that if you make a mistake on overtime, you could be sued individually? The Family Medical Leave Act also defines employer as the employee, anyone acting in the direct interest of the employer, and also I believe the ADEA does as well. But the big one was the Missouri Human Rights Act, because the vast majority of litigation over the past 20 years has been under this statute. It permitted a plaintiff's attorney to join not only the company, but the owners, the HR director, possibly. And this commonly occurred. Why? Why would you do that? Well, one thing, it puts pressure, a lot of pressure on the employer to name the owners. I mean, why do companies incorporate? Why do they do it? Why do they create corporations? Why do you create LLCs? I mean, there's a tax reason, but you don't want the liability. You don't want it. Well, the Missouri Human Rights Act gave an easy opportunity for plaintiffs' lawyers to name owners and potentially HR managers. So that's not a good thing. That's from your standpoint. But I have good news for you. Next slide. There was another significant part of this, and I don't want to lose sight of this. Another reason a plaintiff's attorney would join an HR director. Does anyone here work for a company that's out of state, based out of state? Anyone? What state? California. Something just happened. Okay. Let's assume you get sued in state court in Missouri. California company. Okay. There's the possibility that if you're sued here, California company, Missouri plaintiff, the case could be removed to federal court on something called diversity jurisdiction. Ever heard of it? There's two ways to get to federal court, but that's a way you can do it. If you sue a foreign entity in the state of Missouri, if the case is big enough, you have the right to remove it to federal court. And remember, no plaintiff wants to be in federal court. You don't want it. And what plaintiffs were doing is they would name, if they were suing your company, the company you work for, they'd bring in the California company. Then they'd name, do you live in Missouri? They would name you as well. And that way they couldn't remove it because they didn't have the diversity of citizenship. So this was a big change. So what exactly changed in the definitions? Sub C, employers shall not include an individual employed by an employer. So you're now safe. I can hear a collective sigh of relief right now. You're good. You're not going to be sued individually anymore. And there were some other changes. Does anyone here work for a company that is affiliated with a religious organization? Who are you? Do you mind telling me? Who are you affiliated with? Council of the Churches of the Ozark. Okay. Mark Struckoff. Right. Okay. I don't know if that would count, but I want to briefly talk. There was a significant change in that word Right there, or. Previously, that was and. I know that doesn't look like much, but for those of you who are affiliated, that work for a company that's affiliated with a religious organization, adding that or was a major change. Because there are oftentimes you'll have a college or something that the assets may not be owned by the religious institution, but they may be operated. Maybe the majority of the board are made up of a particular religious organization. By adding that or, it just, all I will tell you now, if you're affiliated with a religious organization, you may not be covered by this act. That was a big help. But anyway, so this is a major change. You are now not at risk for individual liability. So what does this mean for you? Are you totally safe? Should you call Connell Insurance and cancel your employees' practices liability insurance? Call? Okay. No, don't do that. Don't call Randall or Tim and cancel your EPL policies. I'm getting some mean looks back there. No, don't cancel your insurance. You still need the insurance because you still have those other statutes and still you can be sued. But as far as individual liability, you are in much better shape. Damage caps. So we have the causation change. We have the elimination of individual liability. What other changes? Damage caps. Let's take a look here. As I mentioned earlier, one reason why the plaintiffs' bar, why they like this Missouri Human Rights Act, is because the relief it allowed. There were no caps. The Missouri Human Rights Act permits a plaintiff today would permit you to recover back pay. You can recover front pay. What is front pay? That's pay that you recover for a future period of time. Go to trial. Your back pay would be your lost wages till the date of trial. Front pay would be what you anticipate you would lose in the future. You can recover that. You could get emotional distress damages. And by the way, you don't even need a doctor to testify. I mean, you can just put on your client and say, I cried at night and give me $1 million. Seriously. There's a case on that. I'm not exaggerating, am I? You don't need a doctor. You can just say, I cried at night. Give me $1 million. That's the Missouri Human Rights Act. Punitive damages. You can get punitive damages. Attorney's fees. Now that's really the big one. A lot of these cases are driven by attorney's fees. There are cases on the books where after years of litigation, have a very minimal verdict, and then the attorney get all the fees. We're talking six-figure fees. I mean, to take a case to trial anymore, Pat, would you agree you're into six figures? You're into six figures. You get that. Lots of pressure. And again, the federal statute had caps. So the legislature, one of the big goals the legislature wanted to accomplish is they wanted to make the state law more similar to the federal law. Okay? They made the causation standard the same, and they wanted the caps. So under the new changes, we're going to have caps anywhere from $50,000 to $500,000, depending on the size of your company. And you're going to look at employees. Okay. This is a summary of what we're looking at. 50, 100, 200, 500, depending on the size. All right? Specifically, so if, now, in order to be subject to the act, you have to have at least 6 employees, which, by the way, that was another advantage to the Human Rights Act as far as a plaintiff is concerned. That's not a very big employer. Most of the federal statutes only applied if you had 15 or more employees. So if you have less than 100 employees, the damages that you could recover from a plaintiff's standpoint is capped at $50,000. So if you go before a jury, you get a big verdict. And let's assume your back pay was $10,000. But the jury awards you $1 million for the other stuff, whatever you want to call it, punitive damages, emotional distress. And that could happen, Jury gets out of control, they award you $1 million for everything other than the back pay. The defense attorney is going to jump up and say, motion for remittiture, and the court's going to reduce the damages. That $1 million is going to suddenly go to 50. All right? Big change. And you can see the other caps. And it cuts off, there's a typo on the next page. Just so you, under the state statute, it's $500,000 cap for 500 or more, not 300. So let me take you back. Let's compare this to the federal statute. This is the 1981. This is the statute that provides caps to Title VII and the American. This is a summary of the federal statute. I just want to compare and contrast federal and state and show you what the legislature was doing. It provides federal caps for the Title VII federal statute, the Civil Rights Act of 1964, and the ADA, Americans with Disabilities Act. See, it's very similar. $300,000 cap for 500 or more. So there are some small changes. Just want to make you aware of that. Okay. So this is good news for you HR people, right? No more individual liability, and for your employer, you're not facing as large of a risk of damages. I want to talk about procedural amendments. Summary judgment. As I mentioned earlier, one reason why the plaintiff's bar did not like federal court is because every judge has 2 law clerks that their job is to sit around and look at pleadings and find ways to dismiss cases. So the plaintiff's bar, they do not want that situation to occur because they're worried that a court might dismiss their case on something called a summary judgment and they'll never get to see a jury. Okay? Well, that's why you file in state court. State court judges just do not have time to read large motions. They just don't have the time. They don't have the resources. That's why you file in state court, one of the reasons. Well, the legislature made very clear when they enacted these amendments that they want summary judgments to be used more often to keep cases from going to trial. I'm going to go past. I don't want to get in the weeds in this, but let me just say generally, one result of these amendments will be, hopefully, the legislature hopes that more cases on the borderline will be disposed of through a summary judgment process and will not go to a jury. Okay. I do want to talk about this instruction, a business judgment instruction. Let me go back and find it. Okay, what is a business judgment instruction? What is it? There it is. It's in quotations. You may not return a verdict for the plaintiff just because you might disagree with the defendant's decision or believe it to be harsh and unreasonable. What is it? It's a business judgment instruction. Lisa, is that my jury person? Okay. I don't know what the trial was like, but many trials in state court, again, almost all the time they were going to jury, but let's imagine a situation where you're in trial and you're the HR manager, you're sitting there, you're the corporate rep at this trial, and you have a situation where there's not a lot of evidence of discrimination, maybe a stray remark, but the fact pattern is terrible for your employer. For whatever you did to this employee was not good. Maybe this employee that was fired had a sad tale of woe, a very sad story. Okay? And currently, if you have a sad story, a plaintiff's lawyer might take that case to try to get a jury mad at you being the employer and just hope that the jury gets so mad that they're going to punish you, even with scant evidence of discrimination. Now imagine that situation where, again, a case goes to the jury, very scant, if any, evidence of discrimination. But the plaintiff employee was treated unfairly, badly, maybe cursed at, yelled at, it wasn't handled well. Wouldn't you much rather, and just think about the situation where closing arguments occur, and you're looking at the jury and they all start crying, moved, and you'd be thinking, man, this is not going to go well for me when they come back out. You'd probably start settlement discussions right then when the jury leaves, hoping that they wouldn't render a verdict against you. If you're in that situation, it comes up a lot. Wouldn't you rather have the judge instruct the jury on that? Okay? That would be a big deal. You're basically saying, hey, jury, I know you just heard a very sad tale, a very sad story, but you have to follow the law. I mean, you just can't enter a verdict because you believe the employer was being a jerk. That's really what a business judgment instruction is. Wouldn't you like that? And doesn't that sound reasonable? Can you think of any reason why a jury should not be instructed on that? Huh? Does it make sense they should be instructed on that? Well, this was not the law. Okay, because the Supreme Court, I believe, it was the Supreme Court, held that you cannot give a jury this instruction. And this is a big deal. In fact, just a few weeks ago, I was in court in Greene County. I was about to go up and make an argument in another case. And there was a case before my case, and I was waiting for them. It was taking them forever to get done. But those lawyers were there on what's called a post-trial motion. In other words, they had already had the trial, and a verdict had been entered against this, I believe it was the city of Springfield, or either the Greene County, in favor of a police officer for race discrimination. Okay? A verdict had been entered against, I believe, Greene County Sheriff's Department for race discrimination. And the attorneys were there after trial trying to undo the verdict. It was called a motion called judgment notwithstanding the verdict. So the city attorney, the attorneys for the police force were saying, Judge, I know the jury came back with a verdict, but there were problems. Please undo what the jury did. And they were arguing. I was listening. And one of the arguments they made was, we wanted this instruction. And the judge, Judge Cordoni, a very good judge, looked at him and said, that's not the law. You weren't entitled to it. I read the cases, and you can't get this instruction. So this is a big deal. So I just bring this up to tell you the legislature was very intent on undoing a large amount of case law that had been very, very unfavorable to employees for a long period of time. Okay. So it shall be the presumption that for a fair presentation of the case, the jury shall be given an instruction expressing the business judgment rule. Okay. So even if you're a jerk as an employer, you have to prove, a plaintiff has to prove their case. They have to prove that discrimination occurred. Timeliness. Okay. In addition to permitting the business judgment rule, there is also a change when it comes to the administrative process. Now, some of you here earlier, when I asked if you'd ever dealt with a charge of discrimination, indicated that you had not dealt with such a thing before. So I want to take a little bit of time and talk about the administrative process to file a claim under the Missouri Human Rights Act. Unlike many cases, let's assume that you're in an automobile accident. And you're in an automobile accident, someone hit you, they hurt you, they were negligent. The next day, you could hire a lawyer and just go to the circuit court in Taney County or Greene County and file a lawsuit. The next day, if you wanted to. That's not true with the anti-discrimination laws. There's a step you have to take first to get there. And that step is you have to file a charge of discrimination with one or two agencies. On the state level, you have to file the charge with the Missouri Human Rights Commission. That is the state commission that regulates and enforces to some extent the Missouri Human Rights Act. That's what they're there for. They're in Jeff City. Very nice people. On the federal level, you have a number of agencies, but the one you typically deal with is the EEOC. You've heard of the EEOC, Equal Employment Opportunity Commission. You can file a charge there. And there's actually an agreement. The Missouri Human Rights Commission and the EEOC, they have an agreement with one another. It's called a work-sharing agreement. So if you file with the Human Rights Commission, you co-file it with the EEOC in both. So those of you who've got a charge, you look at the top right-hand corner, it's going to have a Missouri Human Rights number and an EEOC number. You file in both. Okay. So that's step number one. You file your charge with one or the other, and you're going to co-file in both. And then you have to get a letter from those agencies. It's called a right to sue letter. It's a permission to sue, right to sue letter. And how do you get that letter? You're a plaintiff's lawyer, you want to sue someone in court. What do you have to do? You just write a letter to the commission. You have to wait a while. You have to wait a period of time and say, Missouri Commission on Human Rights, give me a right to sue letter. And they issue it to you. Okay? And once you get that letter, you're then free to file a lawsuit. You have to do it within a period of time, but you do have a period of time, but you have enough time. But what happens if you're late? The Missouri Human Rights Act provided, it had one thing that was not favorable about the Missouri Human Rights Act. It has a very short statute of limitations. It said that you must file a charge of discrimination within 180 days. That's really, that's not a lot of time if you think about it. Not much time, 180 days. Most statute of limitations are 5 years. So 180 days. What happens if you file it a year later, after the 180 days? Doesn't it seem logical that if you file late after the 180 days, that you would not be able to bring a lawsuit? Does that seem logical? Right? Wrong. I know it seems that way, but we actually had a case, and it came out in 2015 or 16, not long ago, where, anyway, this is the actual provision of the Missouri Human Rights Act that it shows the changes. But what happened was there was a case where there had been a late filing of a charge. It was filed after the 180 days. And for whatever reason, the Missouri Human Rights Commission, the plaintiff's attorney requested a letter, even though the charge was filed late, and they gave the letter, the right to sue letter, to the plaintiff, and they sued. And the employer moved to dismiss and said, what are you doing here? It was late. They filed the charge after 180 days. Dismiss the case, court. Please dismiss it. And the court refused. Said, we're not going to dismiss it because you, the employer, should have raised that issue with the Missouri Commission on Human Rights. In other words, within 30 days from the time they issued the right to sue letter, you should have filed something called a petition for review challenging what the commission did. Therefore, you can't raise it now. It's very unfair. Well, the legislature didn't like that. They did not like that ruling at all. Employers didn't like it. And that now, I just give you that background so you can appreciate the change that took place. You see what they added? The failure to timely file a complaint with the commission shall deprive the commission of jurisdiction. Okay? Later on, if a complaint is not filed with the commission with 180 days of the alleged act of discrimination, the commission lacks jurisdiction. So this permits the employer to raise this timeliness issue during the lawsuit. In other words, now you don't have to bring some sort of challenge immediately with the commission. You can bring it immediately. Okay. I'm now moving out of the Missouri Human Rights Act. I'm going to talk about whistleblowing. Okay. See how I'm doing on time. Does anyone have any questions about the amendments, changes to the Missouri Human Rights Act? Anyone? None? All right. Let's talk for a moment about the public policy exception to employment at will. First of all, what is the employment at will doctrine? We probably have some idea. In Missouri and in Arkansas and most states, we have something called the employment at will doctrine. And it provides that unless you have a contract of employment for a specific term of time, you can be fired for any reason at any time, unless it's an illegal reason. And the converse of that is if you're an employee, you can leave at any time. It's employment at will. Beginning in the 1980s, our courts in Missouri began to carve out exceptions. Our courts did. They're called common law exceptions. So what the courts did is they said, well, there are certain situations where if you were fired, even if you're employed at will, you would have a claim against your employer under what's called the public policy exception to employment at will. What are the four categories? If you could bring a claim against your employer if you were fired for refusing to perform an illegal act or an act contrary to a strong mandate of public policy. Okay? Illegal has to be illegal. You have to point to a statute or regulation. You would have a cause of action if you were fired for reporting the employer or federal employees to superiors or third parties, such as an agency. Third, acting in a manner public policy would encourage. And finally, the fourth one was actually statutory, and I know Pat covered this in his portion, but this would be an example of an exception to the employment at will doctrine. So these were the grounds created by our court system, which provided an avenue for an employee to bring a claim for wrongful discharge, even though they were employed at will. Okay? Even employed at will. And what kind of damages are we talking about? You could get lots of back pay, front pay, emotional distress, punitive damages, wide open damages. You couldn't get attorney's fees, but you could get emotional distress damages, very broad recovery. And there's been some very big verdicts under these claims. Well, the legislature was not happy about this. And so when they made the changes to the Missouri Human Rights Act, the legislature decided that it was time to codify, to put in statute this exception to the employment at will doctrine. So they enacted the whistleblower provisions, the Whistleblower Protection Act. Okay. Okay. Again, it's a codification of wrongful discharge claim. It codifies who is a protected person, who is the sort of person that can bring a claim for an exception to the employment at will doctrine. It applies the motivating factor standard. Before it had been contributing. It adopted the federal standard. All right. And one significant part of this is that it basically undoes what the court system had done. Okay? Because again, the public policy exception had been created by the courts. We're now dealing with this statute. It will be the only remedy moving forward, providing an exception to the employment at will. What about the definitions? Oh, first of all, who's liable, who's not? The states or their political subdivisions are not going to be part of this. I talked to OTC a minute ago. You're good. It specifically has a carve-out for colleges and universities and others, including religious or the religious exception we looked at earlier. And no individual liability. There we go. It shall not include the state of Missouri subdivisions or an individual employed by an employer. And again, it adopts the same language dealing with religious organizations. But who is protected under the Whistleblower Protection Act? Okay. 3 categories. If you're an employee and you report an employer's unlawful act to the proper authorities, you would be covered under this statute. So if there's a violation of law of some sort and you report, if your employer is stealing money or something like that, you go to the cops, you would potentially have a cause of action if you're fired for it. All right? If you report the employer's serious misconduct, you could be covered. And also, if you refuse to carry out an employer's unlawful directive, you would also have a claim. Let's assume you're an in-house CPA and they want you to cook the books, in an illegal fashion that would violate the tax code. You refuse, and they say, "Get out of here. We'll find a crooked CPA. We don't want to see you anymore." Okay, you would possibly have a cause. You would have a cause of action under the Whistleblower Act. Okay, there we go. This is the definition of what a protected person is. Interestingly enough, if I'm not going to go back to the prior slide, but you may recall that previously, prior to this statute, there was a protection for a person who was fired for engaging in an activity that public policy would encourage. Do you remember that? Okay. That is not in here. So one thing the legislature did is they eliminated one category of the public policy exception to the employment at will doctrine. And what would that look like? What would be the sort of conduct that public policy would encourage? And you're thinking, what would that be? Well, I actually had one. Not to get too specific, but about a year ago, I had a client that was sued by an employee under this exception, the public policy exception to the employment at will. And the person that sued my client had a license issued by the state. A license issued by the state. They were a professional. And they claimed that they were fired for missing work because they were in Jeff City defending their license. Okay? Again, they were a licensed person. Something came up through the regulatory authority in Jeff City. They went to Jeff City arguably to keep their certificate. They had a hearing. Okay? And so they brought this claim against the employer saying, well, you fired me because in a situation as a result of me engaging in conduct that public policy would encourage. Because the state of Missouri wanted me to be in Jeff City defending my certificate. Okay. That was the argument. It didn't work out for them, but I'm just trying to give you an example of what that might look like. Okay. Who's not protected? You are not protected if you are a high-ranking employee, such as managers, etc., if your job is to report or provide professional opinions concerning the conduct in question. Number one. Who would that be? Now, I think, there are lawyers in the house, is that right? If you're a lawyer, raise your hand. Are you in-house counsel? Okay. I don't think you're covered. I'm sorry. I'm sorry. I think in my mind, that's one type of person that could conceivably be covered, because why do you have general counsel? Why? Anyway, let's just say it this way. It's going to be interesting to me what the courts do with this. Because in my mind, I would think that general counsel or someone like that should be covered. But the reason companies would hire an in-house lawyer is to advise them professional opinions on what is right and what is wrong. It would seem to me that would be, if you fire your general counsel for advising you to comply with the law, that you should be protected. But nevertheless, we have this language. I personally will be it will be very interesting to see how this plays out. Also, you're not protected if you reported the unlawful conduct only to the person that acted unlawfully. Okay? So, if you're working for a company, something's going on illegal. Did you ever watch Breaking Bad? Anyone watch Breaking Bad? Anyone? Raise your hand if you watch Breaking Bad. I'm almost done with Breaking Bad. I'm like I've made it through the seasons. But you remember, I can't remember the guy that the wife had the affair with. Anyway, he had this company, and he was cooking the books and was being helped with it. But I just give that an example of the boss that cooks the books. In an illegal fashion, violated the IRS rules. In order to be protected under this whistleblowing exception, you would have to complain to someone other than him. All right? In other words, you'd have to go to the IRS or someone else. Okay? And again, colleges and universities, that's a typographical error. It should be employees of colleges and universities are unprotected because they're not covered entities. Okay, again, a person is not protected if you're a supervising managerial employee and part of your job concerns a matter upon which you're employed to report or provide a professional opinion. This could potentially also cover risk management type people. So again, it's going to be very interesting to see what the courts do with this. Damages. Let's assume that you are a covered person, you're an employee who has a claim for wrongful discharge under the whistleblower statute. What can you get? And this is a significant change. You can get the back pay, and you can get any medical bills directly related to the violation. That's going to be very unusual. That's going to be unusual. Then the statute provides for liquidated damages. Liquidated damages. In other words, you're not going to be able to go into court anymore under the public policy exception and claim punitive damages. You're not going to be able to claim emotional distress damages. You're not going to be able to get $1 million if you cry at night. Those days are gone under this exception. You're only going to be able to recover back pay, possibly medical bills, unlikely. And you're going to be able to get liquidated damages. What are liquidated damages and when can you get them? Okay. You can only get liquidated damages if you prove by clear and convincing evidence that the conduct of the employer was outrageous because of evil motive or reckless indifference. That is the punitive damage standard, the current punitive damage standard. But instead of getting punitive damages, you get liquidated damages. Do you see the bold languages? In addition to the amounts, in addition to back pay and medical bills, you can recover an additional double amount as liquidated damages. So let's assume you get $5,000, double that, that would be your liquidated damages. Okay? But the most significant thing is costs and reasonable attorney's fees. Now, I've talked to a number of plaintiffs' lawyers who are very, very distraught. Attorneys who almost entirely do handle employment claims. They're very distraught about these changes. They do not like this because they've worked very hard for the past 20 years to get to this situation that is now being changed. But when they complain to me about these changes, I always point out to them that you have this change. So now, from a plaintiff's perspective, if you bring a claim under the whistleblower exception, you do have the opportunity to recover your attorney's fees, which was not present before. And in my mind, I think that this makes this particular change possibly a very favorable one for plaintiff's attorneys. Just a thought here, so be aware of that. Okay, I'm now moving at, that is all I have for Senate Bill 43. I have one more, and I'm moving very quickly through my outline. But I have two more subjects to cover. There are three cases that came out in the last 12 months that I want to talk about. And the first one deals with supervisor liability for injuries. Supervisor liability for injuries. Okay. And Pat Platter talked at length about workers' compensation. And the great thing about workers' compensation is that it provides a venue other than court to handle claims for workplace injuries. You know, there was a time period, it's been over 100 years now, where if you were injured at work, you actually sued in court. And you had a court proceeding. And workers' compensation stopped that. And it provided, it was an exchange, it was a trade-off. It provided an expedited mechanism for employees to adjudicate their claims, which was good for the employee, but it also limited the amount they could recover to some degree. It was a trade-off. That was the workers' compensation system. And what workers' compensation says is that if you get hurt on the job, you must proceed through the work comp system. You can't, if you get hurt on the job, you can't, if you fall down or you're working and you fall down and you hurt yourself, you can't run to the circuit court and sue your employer. What would happen? I mean, think about that. You're sitting in, you have an employee, falls down, they hurt themselves, and they run, get a lawyer, they sue you in circuit court. What would happen? Well, the company lawyer would file a motion to dismiss and say, hey, this is barred by work comp. Get out of here. This is really dumb that you try to sue me in court when we have the work comp system. Interestingly enough, there is a growing body of case law where, and this has been a relatively new thing, where an employee will get a workplace injury, they file a work comp claim, and then they sue the supervisor. Did you know about this? Heard of it? I'm getting some stunned looks. Right? Okay. It's happening. And there are two cases in the past 12 months, and I want to talk about them. Situations where there was a workplace injury and the injured employee sued the supervisor. Now this, again, I'm be clear, this is not work comp, this is a court case. Sued. Okay. Let's talk about McComb v. Norfus. Okay? A hospital delivery driver supervisor instructed the plaintiff, the employee, to continue driving his route during bad weather conditions. Near the end of his shift, still during work time, okay, at work, clearly work-related. Slid off the road, and he's dead. Okay? Employee's wife brought suit against the supervisors. They go, and what happens? The attorneys for the supervisors files a motion to dismiss, and what do they say in the motion to dismiss? Work comp. Come on, what are you thinking? You can't bring this claim in court. We've got work comp. Get out of here. And the trial court did just that. Granted summary judgment for the supervisors. Right? That's what should happen, right? Well, you know what happens, but I want to back up a little bit and talk about what a non-delegable duty is. And I want to get overly technical, but let's talk about what we're getting at. The employer, you the employer, have certain duties to your employees. Long story short, you have to provide a safe place to work. You have to provide safe appliances and tools, provide warnings when applicable, a suitable number of fellow employees, and promulgate and enforce rules. This is LEAPR, called the LEAPR decision. Okay. So when you have a situation where you're attempting to sue a supervisor for an injury, the courts decide whether or not they're dealing with a non-delegable duty that the employer owes to the employee. Is it a non-delegable duty? Look at the two-part test. Is the injury to be attributable to a breach of the employer's non-delegable duty? If the answer is yes, in other words, the injury resulted solely because the employer didn't provide a safe workplace, then the supervisor can't be sued. Work comp bar. Work comp bar. But what if the court decides that the injury was the result of a duty the supervisor owed to the co-employee? Okay? And the answer is the supervisor could be liable. If the workplace injury can be attributed, again, to the employer's duty, they wouldn't be liable. But in the situation where the workplace becomes unsafe solely through the default of an employee or one of his co-workers, there is a possibility where the supervisor could be liable. Okay? So, this particular case, the Court of Appeals held that the employee could sue the supervisor, the McComb case. It is proceeding. It has been remanded back to the court. I'll just tell you, though, this case is on appeal to the Supreme Court, but I wanted to bring this case to your attention because I do believe it is significant, because it indicates, I believe that the courts currently are expanding the situations where a supervisor could be held liable for a workplace injury. What are the factors that would be considered? Did the employer have a safety policy or procedure in place? Okay. Did they? Okay. Did the supervisor or co-employees follow the policy? Was it effectively communicated? And what they're getting at here is this a situation where you had the safety policies and the supervisor didn't follow it. Okay. If you have a situation where you have a rogue supervisor not following workplace rules, policies, and someone gets hurt, it is possible that that supervisor could be sued in court. Garrett v. Brown. Garrett, a bill poster, brought a negligence action against his supervisor when the cross brace on the ladder he was using to climb a billboard structure snapped and caused him to fall. Again, we had a lawsuit. You go to court, and the attorney for the supervisor, what do? They file a motion to dismiss. You can't sue me. This is a workplace injury, work comp, right? Okay, the trial court grants summary judgment in favor of the supervisor. They appeal, and the Court of Appeals sends it back. Say, hey, no, there's a factual issue. The plaintiff is going to be able to have a trial against the supervisor to see if the supervisor should be held liable for the workplace injury. Okay? Because there's a genuine issue of fact of whether or not the injury was caused by the employer's duty to create a safe workplace or a personal duty owed by the supervisor. If I recall correctly, there was a safety rule that had been violated by the supervisor. Okay. So again, the key point here, when you have a workplace injury now in the state of Missouri, there is a possibility that there could be individual liability for the supervisor. In those situations where the injury was caused by a personal duty that the supervisor owed to the employee. And what is relevant to that inquiry? Safety rules. What was the supervisor doing that caused the injury? Okay. Talk to your you really do need to talk to your supervisors about this. And I believe that we're going to see a lot of movement in the future in this area of law. Any questions about that? Supervisor liability, work comp. Okay. One final case I want to cover. This came out just a few months ago. Under the Missouri Human Rights Act, not only are people protected if they're, the Missouri Human Rights Act provides for 3 categories of protections. You have protections for people who are discriminated against, people who are fired, demoted because of their membership in a protected category. We also have anti-retaliation provisions. So if you file a claim under the Missouri Human Rights Act, or if you make an internal complaint of discrimination, you're protected from retaliation. Okay? You can't retaliate against someone for making a claim of discrimination. You can't do it. It's retaliation. But there's also a provision in the Human Rights Act that protects people for associating with protected people. Okay? In other words, if you associate with someone that's disabled or whatever and you're fired for it, there would be a potential claim in your favor. What does that look like? What would that look like? Johnson v. I'm not even going to try to pronounce this. Fuse? Okay. Automotive Network. Johnson, who was employed by this company, long-term employee. And by the way, there are certain, I'm going to digress for a moment, but I often tell, a lot of times HR people will ask me the question, when should I call my lawyer on an employment situation? Okay. I want to digress for a minute. There are certain there are certain red flags that come about in employment situations that I believe should result in a phone call to your lawyer. Okay. For example, if the person you're about to get rid of, fired, demoted, is a member of a protected category. I mean, if you're in a situation where you're an employer, everyone is white, you have one black employee, you're about to fire that black employee, that might be a situation where you call your lawyer. Okay? All right? If you have a situation where the employee has made complaints of violations of law and you have to fire them, you need to call your lawyer. If you have a long-term employee, 15 or more years, and you're about to get rid of that person, I do believe that's a warning. That's a red flag. Okay, we're not talking about the 6-month employee that's just not working out. If you have a long-term employee that you're about to get rid of, I do believe that is a situation that you need to approach cautiously. Okay, and I only point that out because that's what we have here. Johnson was employed for 16 years before her termination. She received health benefits. Okay? All right? She had a son with a severe medical condition. Okay? and she was fired from her job, allegedly because of elimination of position. Okay? She claimed that there were statements being made by the employer, this is her claim, that there were statements made to her by the employer at the time of the firing that to the extent that they were happy, or that she needed to be aware that she would no longer be able to rely on the medical insurance policy to cover her son's extensive medical expenses. For you HR people, never say that. Don't ever. That is not something. Okay, when you're handling a termination meeting, this would not be something that you would say to the employee. Okay, but they, according to the plaintiff, they said it. All right. The plaintiff also claimed that there were other employees whose positions were not who were eliminated, who were offered new positions, but she was not. Okay? So what's her claim? She brought her petition under the Missouri Human Rights Act saying that she was fired because of her association with a disabled person, her son. Okay? That's her claim. You fired me. You weren't eliminating this position. Look here, there were other people whose jobs were eliminated. You gave them other jobs, but not me. Why did you treat me differently? You treated me differently because of my disabled son. You had all those medical expenses. He's disabled. I'm his mother. I'm associated with him. That's why you fired me. Brought the claim. All right. I'm not going to go on to the procedural history. The employer tried to remove it to federal court. That failed because they were untimely. But then the employer got smart, and they looked at this situation. I mean, I can tell you, from an employer, you look at it, these are really bad facts for me. I do not want this case to go to a jury. We have a long-term employee, sick kid. My HR manager made some really stupid statements in the termination meeting. Please, dear God, I do not want to go in front of a jury. I don't want that to happen. I can imagine the business owner going to the attorney, please get me out of this. I do not want to go to trial. So the employer files a motion to dismiss, or a motion for, I think it was a motion for summary judgment. What is the argument? It's a great argument. This case is preempted by ERISA. ERISA. What is ERISA? ERISA is a federal statute that involves all welfare benefit plans, group health plans, disability plans. You all have them, right? You have health benefits. ERISA governs those types of plans, okay? And ERISA preempts, supersedes all state law, most state law that deals with health benefit plans. So this creative lawyer filed this motion, say, hey, you can't sue me under the Missouri Human Rights Act. You're alleging this case falls under the exclusive province of this federal statute, ERISA, okay? Because under ERISA, there is a provision that provides that you can bring a claim if you're discriminated against for asserting rights under ERISA. There's ERISA. It says, it shall be unlawful for any person to discharge, fire, suspend, expel, discipline, or discriminated against a participant or beneficiary for exercising any right to which he is entitled under the provisions of this plan. So the defense lawyer goes to the court and says, hey, look, court, here's ERISA. It provides a remedy in this situation for this person. Moreover, ERISA is the exclusive remedy, and it supersedes all state law. Dismiss the case. The court noted that the petition revealed a rationale for termination. They revealed the only reason that the plaintiff asserted that was wrongful for the discharge was knowledge of the high costs of the insurance for her son. Therefore, the court found that it fell within ERISA's provisions. Case dismissed. Case dismissed. And interestingly enough, I don't know if it's on the slide. Yeah, The court actually was going to dismiss it with prejudice. With prejudice means can't bring it again, but they finally convinced the court on appeal. And this is really where I think the plaintiff got ripped off. Originally, they dismissed it with prejudice. It went up on appeal, and the court said, well, it's okay to dismiss it, but it needs to be without prejudice, meaning you can file it again. And you can file it again, but it's going to have to be in state court. I haven't followed this after this, but the problem is there's a 2-year statute of limitations for ERISA retaliation. I suspect that by the time this case got resolved, they were out of time. So this lady probably had no recourse in federal court. By the time it got resolved, that 2-year statute of limitations, I suspect, had elapsed. This is all I have for my seminar today. Are there any questions about this? Any? You've been a great group. Thank you. I didn't call on too many people. No questions? Come on. Most of this has been good news. You can't be held liable anymore under the Human Rights Act. I deliver good news today. All right, Randall, it's all yours. Thank you again.